Okay, good morning, everyone. Thank you for taking the time to log on and attend this morning's webinar. My name is Emily. I am the Marketing and Communications Coordinator here at Vigorate. And just before I pass over the webinar to Sean, I just want to remind everyone that if you have questions at all throughout the webinar, please type them in on your GoToWebinar question box on the side of your screen, or you can tweet us at Vigorate Digital, and don't forget the hashtag #DemonstrateWebinar. We will be answering questions at the end of the webinar, and any questions we don't get to today during the webinar, we will answer on our Vigorate Digital LinkedIn page later today, so you can look out for that. Just before we jump into the CASL talk, I just want to briefly mention our next webinar in the Demonstrate series, which will take place on March 27th, and is going to be covering responsive design best practices. So for more information about that upcoming webinar, you can register for our Demonstrate webinar notifications on our website, vigoratedigital.com. Okay, so yeah, you can tweet in or you can write your questions in on the side. So today's speaker is Sean Brown. He is a partner with Novations LLP, a preeminent Canadian law firm that advises companies, industry associations, and other private and public sector organizations in connection with a broad range of Canadian regulatory regimes. Sean has several years of experience both in the public and private sectors with a strong focus on e-marketing, e-commerce, privacy, and access to information. As well, Sean actually assisted the federal government in developing certain aspects of Canada's anti-spam legislation. So without further ado, I'm going to pass the torch on over to Sean.
Great, thank you, Emily. Just taking control of things here. Okay, thank you. Thank you, Emily, and everyone at Vigorate for organizing and having me here. I think now is a pretty good time to be doing this update on the anti-spam legislation because there have been a few notable developments since we talked last. I think the last session we did was an in-person event in September. So since then, we've seen guidelines being issued by the CRTC, and we've seen draft regs published by Industry Canada, which is sort of the final piece of the puzzle in terms of bringing the law into force. So we're assuming that everyone on this call has a baseline knowledge of the legislation and what it's about. So we're not going to spend a lot of time talking about the basic requirements under the law and really try to get to what is new and focus on the update component of the presentation. So I'm going to talk a little bit about status because that is very important, and there are a lot of questions around the status of the legislation. Talk briefly about the rules that apply to sending commercial electronic messages, but again, that's more to set the stage for some of the newer information that we have. Talk about the draft Industry Canada regs because there are some notable issues in those regs that are potentially relevant to many senders. And then finally, talk about what I am seeing as some of the key compliance issues under the legislation, which will really set the stage for the Q&A at the end. I have to say that this is not legal advice. I think that's obvious to everyone, but it's more my personal views based on my knowledge and experience and assumptions about how the legislation is likely to be interpreted and applied. So everyone knows the law was passed at the end of 2010. 2011, we saw Industry Canada and CRTC regs published for comment. Both of those entities are required to pass implementing regulations before the law can come into force. And just to remind everyone, Industry Canada is the government department responsible for the legislation, and the CRTC is the enforcement agency under the law. In March of last year, the CRTC regs were finalized. In October, we saw CRTC guidelines published, which we'll talk about a little bit. And then just last month, Industry Canada published their second set of draft regulations for comment. The comment period closed on February 4th. Now we're waiting to see these regs finalized. It's possible that they could be finalized spring or summer before the Parliament takes its summer recess. Also, the government intends to establish a spam reporting center, which would be operated by the CRTC, which will serve largely as a repository for evidence that could be potentially used in actions. So right now, it would not be possible based on timing and assumptions about how things will play out for the law to come into force before 2014. It seems reasonable to conclude that the government will give at least 6 months following the finalization of the Industry Canada regs before the law comes into force, possibly longer. So we could even be looking at a little bit later into 2014. CASL does a lot of things. It's an anti-spam law. It's also an anti-malware law, so it creates rules for the sending of commercial electronic messages, creates rules for the installation of computer programs. We're not going to get into this today because this is going to be a fairly brief conversation, but it's important to be aware that those rules apply to all forms of computer programs, including mobile apps, and possibly even the use of cookies. The law applies very broadly. It applies to all commercial electronic messages sent to or from any computer system located in Canada. It's more than just email. It applies to many forms of electronic messaging, including email, as well as instant messaging, SMS, text messaging, certain forms of direct messaging that can take place on social media platforms such as Facebook or LinkedIn Mail. For the time being, voice and fax communications are explicitly carved out from the legislation because they're covered by the do not call list rules. The most important definition of the legislation is the commercial electronic message, and we've talked about this before, but I think it's worth coming back to because we're seeing some guidance and indication from the CRTC that they intend to interpret this concept very, very broadly, perhaps even more broadly than it would seem apparent based on how the legislation is written. The law itself says that a commercial electronic message is any electronic message where it would be reasonable to conclude that it has at its purpose, or one of its purposes, to encourage participation in a commercial activity. And this specifically includes anything that promotes a product or service or a business opportunity, or anything that promotes an individual who does one of those things. So one of the most fundamental compliance issues, and we'll talk a little bit more about this later on, and I'm assuming it'll come up in questions, but one of the key compliance issues we're dealing with right now is the threshold between a commercial and a non-commercial message. And again, all indications that we're seeing right now from the CRTC is that this threshold is very, very low. We can sort of categorize the main requirements for senders into 3 categories. The first and most important, of course, is the requirement for consent. There are identification requirements that apply when we're obtaining consent and in the body of every electronic message that's sent. And of course, there are unsubscribe requirements as well. The law says that consent can either be express or implied. The implied consent provisions are often where we look first to see if we need express consent to send the message. And there are really 4 different forms of implied consent. The first bullet is the most important when we're talking about business-to-consumer communications, and this is the existing business relationship. And there are 4 or 5 different categories of an existing business relationship that are defined in the legislation. For example, if a consumer has made a purchase or has been part of an agreement, for example, a cell phone contract, within the last 2 years, then consent is implied to send a commercial electronic message to that individual. So express consent is not required unless the individual unsubscribes. Also, if an individual has made an inquiry or an application into services offered by the sender, then the sender has a 6-month period to follow up with a CEM. Existing non-business relationship arises as it implies, non-business type of context, so voluntary or charitable context. Number 3 and 4 are very similar. So if the individual, the recipient, has conspicuously published their electronic address or provided their electronic address directly to the sender, then consent is implied to send that individual a CEM. However, there's a very important condition attached to both number 3 and 4, in that any communications have to be related to the recipient's business, professional, or official capacity. So these are really more relevant in a business-to-business context. Express consent. So I want to walk through this slide just in a little bit of detail because we know what the requirements are under the legislation. And then in March, the CRTC added a little bit more guidance in the form of regulations, and then the actual guidelines, which were published later last year, add some more clarity and detail to their regulations. So the law itself doesn't really say a whole lot in terms of what express consent means. It just says that we have to provide clear notice. We have to describe the purposes for obtaining express consent. So what exactly is the individual consenting to? Are they consenting to a newsletter? Are they consenting to all forms of commercial communications? Does this potentially include communications from partners and third parties, et cetera? We also have to provide prescribed information when requesting consent, which is prescribed in the CRTC regs. And the regs say that we need to provide the name of the person who is sending the message, also the name of the person on whose behalf the message is sent, if different, and we're going to talk a little bit about exactly what this means. Contact information for either of those persons, which includes a mailing address and any one of a telephone number or an email address or a web address. And we have to provide a statement that consent can be withdrawn. The CRTC guidelines go a little bit further, and they provide the CRTC's views on how some of these requirements can be specifically operationalized. And one of the biggest questions that often came up under the legislation is whether a person seeking consent can use a pre-checked box. And the CRTC has stated quite clearly their view that pre-checked boxes cannot be used. So in the CRTC's view, express consent specifically means opt-in consent, not opt-out. So the default has to be that an individual is not consenting and they have to take some form of action to actually opt in to receiving that communication. Now the CRTC did say that if an individual is required to enter their email address into a field next to the statement requesting consent, that a separate checkbox is not required in that situation. The guidelines indicated the CRTC's view that people should be sending confirmation messages. They have since been clarified that, of course, that is not a legal requirement because it's not actually required in the legislation or the regulations. It's just their opinion that following up with a confirmation message, i.e. a notified opt-in situation, is just good practice. The law requires any person seeking consent to obtain and store evidence of consent. So anytime you claim to have express consent, the onus is on you to then follow up and prove that you have consent if it's ever in question. In terms of written consent, so this includes consent obtained electronically, a record of the date, time, and the purpose, the manner, retained in a database should be sufficient. Now the guidelines stated the CRTC's views on what would be sufficient in terms of oral consent. And they stated that either a complete audio recording, so if, for example, if consent is requested over the phone, or verification by an independent third party without without really saying exactly what that means. They've since then suggested that they would not be the only forms of evidence that would be necessary to prove oral consent, which is a good thing because in many cases this just would not be practical for a sender to obtain these forms of evidence of oral consent. These are some of the examples that are provided right in the CRTC guidelines. I think they speak for themselves in terms of the CRTC's views on what would and would not be considered appropriate forms of obtaining express consent. The identification requirements that apply when sending a commercial electronic message are very similar to the identification requirements that apply when obtaining express consent in the first place. So I'm not really going to go through these. And we've talked about the unsubscribe mechanism before. There's nothing really new here other than that the CRTC regs state that the unsubscribe mechanism must be able to be readily performed. If you recall, the previous version of the draft CRTC regs stated that an unsubscribe mechanism must be able to be performed in, I believe, no more than 2 clicks. They received a number of comments that that was too prescriptive, so they backed off a little bit on that and provided a little bit more of a flexible standard. This is just an example that we wanted to use, an example of something that is not uncommon in the email industry. And this is sending an email after somebody has unsubscribed and indicating that the individual has unsubscribed and a potential effort to try to recapture that individual onto the list. And I think it's pretty clear under this legislation that this type of communication would not be allowed. If we send this message after somebody is unsubscribed, there is a very good chance that this is a violation and could be the subject of an enforcement action. We've talked about how the legislation is enforced in the past, so I'm not going to run through this slide. This is more in there for reference purposes, but just to recall, the CRTC has the ability to impose very large administrative monetary penalties, up to $10 million per violation. There is also the private right of action, which allows any individual affected by a violation of the legislation to sue for actual and or statutory damages. So jumping right into the Industry Canada regulations, the legislation itself entirely excludes any commercial electronic message sent between 2 individuals who have a family or personal relationship. This makes these definitions very important. The definition of a family relationship is fairly straightforward, and it's based on the definition in the Income Tax Act. The definition of a personal relationship is much more challenging. So when Industry Canada introduced this concept into the legislation, they then committed themselves to defining what this is, and there really were no existing precedents in Canadian law on how to define a personal relationship. When they first defined this in the first round of draft regs, it had a specific requirement that the individuals would have had to meet in person in the past. And this was flagged as one of the key issues by stakeholders who commented on the regulations as being too restrictive, based on the fact that many relationships are now formed online and that 2 individuals may have never met in the past. So what Industry Canada did was they relaxed the requirements a little bit and introduced what is effectively a reasonableness test. So the one specific requirement is that the 2 individuals are required to have had a direct, voluntary, 2-way communication in the past, so that replaces the in-person meeting. And then a personal relationship would be deemed to exist if it's reasonable in the circumstances to conclude that the relationship is based on all relevant factors. And they They include a non-exhaustive list, which includes the sharing of interests and experience, the frequency of communication, a length of time since the party has communicated, and if the persons have met in person, that would lend more weight to the finding that it would be a personal relationship, although that's not a necessary requirement anymore. I think this is important. We'll talk a little bit more about this in a few minutes, but the personal and family relationship exemption, I think, is going to be quite important for refer-a-friend type promotions. So the fact that they've loosened this up a little bit makes it potentially more useful to senders. Industry Canada also introduced a number of new exemptions in the regulations. For one, the regulations would exempt business communications within organizations or between organizations where the two organizations have an ongoing business relationship. So these are sort of routine business communications that might be considered to be a commercial electronic message by virtue of the definition in the legislation, but not necessarily marketing type communication. So we're not necessarily trying to sell something to our colleagues, but we might be talking about a commercial activity, and therefore the communication would be captured by the legislation. Anything that is a response to a request, inquiry, complaint, or is otherwise solicited by the recipient would also be exempted from the legislation. An interesting one, and Industry Canada indicates that this is largely to deal with very specific scenarios, for example, where an American is traveling to Canada and happens to open an email message on their laptop while in Canada. The way the law is written on its face, it would probably apply to that message because it applies to any message that is sent or accessed on a computer system located in Canada. So they've stated that a message would be exempt if it is targeted to a non-Canadian and advertising products not available in Canada, and where the sender could not reasonably be expected to know that the recipient is in Canada. So this is really intended to capture those specific scenarios, but it would also seem to apply where an American brand is targeting American consumers, but may inadvertently have a few Canadian recipients on their list where they couldn't reasonably be expected to know that they were Canadian. So, for example, someone is using an @gmail.com address. This would seemingly exempt those types of communications and prevent the sender from being subject to enforcement action or a lawsuit in that case. Anything that is sent in order to enforce a legal right, for example, a court order or a copyright notice, assumingly a debt collection notice, would be exempted. And finally, there is an exemption from the need for consent for third-party referrals. And this is really intended to apply in a one-on-one situation. A lot of salespeople in various industries, a lot of professionals rely on referrals as a business development strategy. As an example, if somebody really likes my services and wants to refer me to a colleague of theirs, they could provide their colleague's electronic address directly to me, and then I could communicate directly with them. Without this exemption, the legislation wouldn't allow that because I wouldn't have any form of consent. So this requires the referring party to have a personal, family, or existing business relationship with both the sender and the recipient. And again, that's an exemption from consent only, not an entire exemption from the legislation. The Industry Canada regs also establish the conditions for using consent that is collected on behalf of an unknown third party. So this is where we don't know who the third party is at the time that consent is collected. And this is really intended to apply to situations where a list is created and built and then actually shared with another party in the future. There were some stakeholder comments that these requirements were a little bit too complicated, and I think Industry Canada, their views are basically if you're going to actually collect, build a list, and share it, then you are going to be subject to more complex requirements. And in a nutshell, the rules require unsubscribe mechanisms that are managed across organizations. So if I build a list and then I actually share it with another party in the future, their unsubscribe mechanism has to coordinate with my unsubscribe mechanism because they have to be able to unsubscribe from communications from that party as well as communications from me and any other party who may have access to that list as well. And I think the lesson to draw from this is that list rentals are much better done if we're not actually sharing the list, but we are having the list owner deliver our content to their own subscribers. So just to return to this issue and the question of when a message is commercial, again, the definition of a commercial electronic message is quite broad. And I often get questions about transactional and relational type messages because these are concepts that people are familiar with under the CAN-SPAM Act. And just to be clear, CASL doesn't actually define a transactional or a relational message. Now there are a list of types of messages in subsection 6.6. And these include messages that are used solely to deliver warranty information, subscription information, that confirm an already completed transaction. This would include things like receipts, actually delivering the product. So if we're delivering a product electronically, the law says that if a commercial electronic message solely does one of these things, then it's exempt from the need to get consent, but not exempt from the identification and unsubscribe requirements. Now, a plain English reading of the legislation would lead to a common sense conclusion that if a message solely confirms a transaction or solely provides warranty or safety or subscription information, then it's probably not a commercial electronic message in the first place. This list of forms of communications was added during the committee review process after concerns were raised by stakeholders that the law would inadvertently apply to these types of communications. And in my view, it wasn't very well thought out because now it implies that these types of communications are commercial electronic messages when in my view and in many people's views, they are not commercial electronic messages. So we're sort of left with this ambiguity, and the CRTC seems to be leaning towards an interpretation that because these messages are specifically referred to in subsection 6.6, that they are commercial electronic messages, even if they don't include any promotional or other forms of commercial content, which can be quite problematic and will potentially require a lot of changes for senders based on how they have already been treating these types of messages in their systems. So again, the threshold for when an electronic message becomes commercial is very low. The CRTC has expressed an opinion that even a link to a home page on an otherwise non-commercial message, and as an example, this could be a message from a service-related message having to do with servicing a product, would be rendered a commercial electronic message merely because there is a link to a home page in the signature line of that message. Another compliance issue which has raised a lot of questions and the CRTC is currently considering is what it means to send on behalf of others. So Section 6 of CASL states that a message must identify the person sending a message and the person on whose behalf the message is sent, if different. So this really begs the question of what does it mean to send on behalf of another person? Would this, for example, include an ESP who's providing infrastructure and certain services that allow an email message to be sent? This could potentially apply to advertising agencies and any other service providers that are involved with the creation and sending of an electronic message. I think the better interpretation and the more common sense interpretation is that this is intended to apply in a list rental type scenario. And again, this is where I own a list and I'm actually delivering the content on behalf of a brand. So in that case, I'm sending on behalf of the brand, and I am the person who actually has the relationship, the consent-based relationship with the subscribers. So I'm the person who is sending. The CRTC seems to be willing to acknowledge that at least certain forms of service providers shouldn't need to be identified in every message. And their guidelines state that a person who may facilitate the distribution of a CEM but who has no role in its content or choice of the recipients need not be identified. And again, this would seemingly capture for some service providers, but we would like to see a little bit more clarity and more specific guidance on this issue that would provide a little bit greater comfort that ESPs and advertising agencies and other providers would not need to be identified in every commercial electronic message. And finally, I decided to include this because I get a lot of questions about refer a friend type promotions. And without being able to say unequivocally that yes, they can or cannot be done, I think it's better to sort of walk through some of the key considerations and some of the most relevant provisions under the legislation. So if we start with the general proposition that a commercial electronic message cannot be sent without consent, we know that even if someone says, my friend or my group of contacts would like to know about this product or service, that we probably can't send to those contacts. However, consent is not required if there's a family or personal relationship. In fact, the law doesn't apply if the message is sent between two individuals with a family or personal relationship. So if the refer a friend functions in a way that would be interpreted that the message is actually sent from the individual making the referral to their friend or family member, then the law seemingly wouldn't apply. However, that's not the end of the story, because the legislation says that it's prohibited to aid, induce, procure, or cause to be procured the doing of any act that would violate the legislation. For example, sending a commercial electronic message without consent. What this means is that if a sender offers incentives or, for example, does not provide or establish any limits on the number of messages that can be sent at once, this could be viewed as encouraging individuals to violate CASL. For example, if an individual uploads their entire address book of 100 contacts or 500 contacts, it would likely be considered to be unreasonable in the circumstances for the sender to believe that the individual is actually only sending communications to individuals with whom they have personal or family relationships. So in that case, the brand could be liable if they're viewed as procuring or inducing the individual to violate CASL. So that's the end of my formal presentation, and I'm happy to respond to any questions that might have come in.
Excellent. That was awesome, Sean. Thanks so much. So we did actually have some questions come in during the webinar, so we will ask them now. I'm just going to switch back over to my screen. Okay, so first question. When you mentioned implied consent, you mentioned recipient has disclosed electronic address to the sender. In the case of e-receipts in a retail environment where the email address has been given for the purposes of emailing the receipt to the customer, can they reach out via a CEM further than just the receipt?
Yes, yes. But the proper implied consent provision in that case would not be the implied consent based on the consumer having provided their electronic address directly to the brand, because if you recall, that particular provision requires that any message sent under that form of implied consent be related to the recipient's business, professional, or official capacity. So we can't rely on that provision. However, if the person is receiving a receipt, that implies that they have made a purchase. And we have 2 years to send a commercial electronic message based on a purchase. So yes, you could send a commercial electronic message other than the actual e-receipt.
Okay. Okay, perfect. So the next question, what are the other forms of oral consent that would be accepted if an audio recording isn't practical?
What the CRTC has done here is they've basically stated their views on what the gold standard would be. From a practical perspective, the fact that anyone claiming to have express consent bears the burden of proving it means that they have to have some form of proof. And this is in a civil context. It's not a criminal context. In a criminal context, things have to be proved beyond a reasonable doubt. Typically, in a non-criminal context, we have a sort of lower form of standard. So a balance of probabilities is often referred to as a civil standard. That means it's the CRTC's job to evaluate the available evidence and make a determination as to whether it's reasonable to expect that consent has been given in circumstances. So the fact that they've said that you need an oral recording or verification by an independent third party is really kind of a way of saying that, you know, this is, if you do this, you're going to be fine. But in reality, it's the CRTC's job to dig a lot deeper, look at all the surrounding circumstances, look at the extent to which, in the past, spammers have relied on false claims of oral consent, which I'm not aware of ever being an issue. So all that to say that, in my view, I think it should be sufficient if you have a database that marks the time and date and form of consent. For example, if consent is obtained by a customer service representative over the phone, well, that should be marked down, saying that it was obtained at this time by this representative and marked down in the system. Again, I can't warrant that that is going to be sufficient, but I would have a real problem if the CRTC found that that was not sufficient evidence of oral consent.
Okay. Okay, perfect. The next question. In the Industry Canada Regulations new exemption slide, you mentioned third-party referrals where referring party has personal, family, or existing business relationship with the sender and recipient. The question is, who is held accountable in this situation if just relationships aren't proven, the person giving the referral or the company sending the message?
The regulations obviously don't specify that, but at the end of the day, it's going to be the sender who's held accountable, because if they send outside of what's allowed under the legislation or under that particular regulation, then they're the one who has violated legislation. So again, this is going to have to involve a consideration of the circumstances and whether the sender had reason to believe that it was reasonable in the circumstances to assume that the individual actually has a personal or family relationship. And there are a few more requirements that are worth mentioning here. So the regulation actually requires the sender to identify the person who made the referral, and the purpose of putting that in there is to sort of add another layer of accountability. And if the person making the referral knows that they're going to be identified in the message, well, then they're likely only going to make a referral in situations where they're comfortable being identified and where they're comfortable knowing that the recipient would actually like to hear from the sender. Also, for the time being, the regulation only allows a sender to send one single follow-up communication based on a referral. I would actually like to see that expanded to two, because I think there are a lot of cases where the first message might not be received and a second follow-up message would be appropriate. But and just to be very clear, this third-party referral regulation would only apply to individuals. So it's not going to allow me to refer a brand or a company to an individual. It actually specifically refers to individuals as opposed to persons, because persons can include corporations. So this is really intended to apply in those personal one-on-one salesperson or professional type situations.
Okay, perfect. So we do have a number of more questions, but I think I'll just ask two more just to be respectful of everyone's time. And again, any questions we don't answer right now, we will be posting on our LinkedIn page later today, so you can check there. So the next question, for refer a friend, if someone forwards to their friend and the email appears to be from John, their friend, from the friendly from, but the from address is actually the original brand's, is that still compliant?
Okay, so just to be clear, we're talking about sort of the mechanics of how this would work.
Yeah, so I think the friendly from would say John, who is the friend, but the actual address is the original brand that sent the message.
It's hard to say unequivocally exactly how that would play out. I think those are factors that would go into a determination of who is actually sending the message and potentially on whose behalf it's sent, who is doing the sending, whether it's the individual or the brand. We also have to think about the provisions under the Competition Act that prohibit false or misleading information. So if it's actually delivered from one system, we may have a requirement to ensure that the from address reflects where it's actually being sent from. So without being able to provide a very clear or simple answer, those are some of the considerations, and I'd be happy to maybe explore that in a little bit more detail offline.
Okay, perfect. The last question we'll ask right now, the legislation at this point seems very ambiguous. Do you think it will become more black and white before it comes into play, or will there always be that level of subjectivity, and what does this mean for marketers?
There is always inherently going to be certain ambiguities and certain things that are uncertain. It's an extremely important issue for all senders, service providers, and that's part of the reason why certain stakeholders and certain stakeholders that I'm involved with are really pressing the CRTC and trying to get more clarity and guidance on specific issues, including the definition of a commercial electronic message and what it means to send on behalf of another person, how CASL applies to cookies, all these issues. So the CRTC has already issued guidelines and seems to have indicated that they are likely to issue more guidelines before the legislation comes into force. So yes, we will likely see more clarity and more guidance and know more about some of the specific issues before the law comes into force. But this is a complex piece of legislation. It's very long. There are issues, new issues that seem to be popping up every day that haven't even been conceived of. So there are inherently going to be ambiguities in certain things that we just cannot advise on with a lot of granularity and detail until the law actually comes into force and we start seeing enforcement actions. And CRTC's views may differ from how a court views certain issues. Some of these issues may not be settled for a long time.
Okay. Okay, perfect. So that's all we'll get to right now. But again, any questions that haven't been answered here will be on our Vigorate LinkedIn page later, so you can check there. I just want to thank everyone for attending, and thank you very much, Sean, for the great webinar. Don't forget our next webinar in the Demonstrate series will take place on March 27th, and we'll be covering responsive design best practices. Again, for more information about upcoming webinars, you can register for our Demonstrate webinar notifications on our website at vigoratedigital.com. Thanks again, and have a great day.